Texas judges can refuse to officiate same-sex weddings. It's October 30th, 2025, and these are your headlines. I'm Sydney Henry, filling in for Brandon Waltons, who's on vacation. The Texas Supreme Court has clarified that judges in Texas are not required to officiate same-sex weddings if doing so would violate their sincerely held religious beliefs. This clarification, announced late last week, comes in the form of a comment added to Canon 4 of the Texas Code of Judicial Conduct. Canon 4 governs how judges conduct activities outside the courtroom to avoid conflicts with their official duties. Previously, some lower courts interpreted the code to mean judges were obligated to perform same-sex ceremonies if they also chose to officiate heterosexual weddings. But the state's highest court now says that's not the case, stating directly it is not a violation of these concerns for a judge to publicly refrain from performing a wedding ceremony based upon a sincerely held religious belief. The issue rose to prominence in 2019 when McLennan County Justice of the Peace Diane Hensley received a public warning after performing traditional weddings while referring same-sex couples to other officiants. Hensley challenged the warning, arguing it violated her rights under the Texas Religious Freedom Restoration Act, which guards against government-imposed burdens on religious practice. Although the warning was eventually removed, court challenges continue, including a related case by Jack County Judge Brian Umphris, who also argues that forcing judges to officiate any wedding violates constitutional rights. The Supreme Court's clarification is expected to significantly impact both ongoing lawsuits and judicial practice statewide, giving Texas judges explicit legal ground to decline officiating at same-sex weddings for religious reasons. Acting Comptroller Kelly Hancock has announced an immediate freeze on all new and renewed certifications for the state's historically underutilized business, or HUB, program. This move aims to ensure that Texas's government contracting program aligns with the state and U.S. constitutions, as well as Governor Greg Abbott's executive order, which bans any race or sex-based preference when awarding state benefits such as contracts. The halt affects new applications and renewals, pausing HUB participation in state procurement while the program undergoes a comprehensive legal and administrative review. According to Hancock's office, the review will focus especially on the constitutionality of diversity, equity, and inclusion, or DEI initiatives, in light of recent court decisions. The goal, Hancock says, is to ensure that all Texas businesses have an equal opportunity to compete for government contracts. Hancock said, quote, "Texans deserve a level playing field where contracts are earned by performance and best value, nothing more, nothing less," unquote. During this freeze, the Comptroller's office will continue collecting data on business participation and plans to rewrite procurement rules so they're strictly race and sex neutral going forward. Importantly, existing contracts and general state business reporting are not affected, and eligible companies can still register to bid on projects through the state's centralized master bidders list.
But every day I run into something that I'm dealing with the county judge.
Judge Bray recused himself, but as we'll soon see, he couldn't resist reinserting himself into the process.
Signing notices, setting deadlines, accepting candidate applications, rejecting candidate applications. The dispute that ensued thereafter was centered on whether or not Judge Bray had the authority to do those things or should have been doing those things.
Head over to TexasScorecard.com today to watch our latest documentary, Kicking the Circle. A required reading assignment at Texas A&M University is raising serious concerns over its promotion of controversial racial policies. In a sociology course titled Introduction to Race and Ethnicity, students were assigned a reading by Barbara Reskin that calls for the creation of a new cabinet-level federal agency to oversee the elimination of race discrimination in every area of society. The same reading suggests government-mandated lower property taxes in predominantly Black neighborhoods and claims that various institutions, including Major League Baseball umpires, demonstrate racial bias. The course, taught by Dr. Longfei, instructs students to adopt a racialized lens, exploring concepts like microaggressions, Asian hate, and algorithmic bias. Reskin argues that racial disparities must be addressed by centralizing authority and implementing aggressive government interventions, a viewpoint that some experts, like Dr. Thomas Sowell, strongly dispute, a fact notably not mentioned in the reading. In response to other scandals regarding A&M course content, the System Board of Regents has promised a full audit of course materials to ensure compliance with state laws and uphold transparency in taxpayer-funded higher education. For more of today's stories, go to TexasScorecard.com.